Hello, everyone, and welcome to the AHF Podcast. I'm your host, Joe Schwab. My guest today needs almost no introduction. Dr. Joel Matta is joining me from Colorado to help kick off a new series in the podcast. Lorne Michaels, the legendary producer of Saturday Night Live, has had the unenviable task for almost 50 years of deciding what sketches get aired and what sketches don't. And so many sketches are used at the show's rehearsal that Michaels often makes decisions at the last minute before the live show begins. Sketches that are cut for time are often not seen by the main audience, but so many of them had such good material that Michaels even created a whole separate television series around them. It ran from 2013 to 2019. Well, the same thing can happen when putting together a meeting program. For one reason or another, talks may end up getting cut for time. But thanks to the new AHF Podcast Cut for Time series, that doesn't mean they don't get their own opportunity to be heard. Among his many passions, Joel Matta feels strongly about the relationship between surgeons and industry. And an important part of that relationship is the contract. Dr. Matta has as much or more contract experience as any surgeon innovator out there. And today, he's here to share his thoughts about the contracting process with us. Joel, welcome to the AHF Podcast.
Thanks, Joe, and thanks for organizing this. Kind of the point of view I'm bringing about is that I'm in favor of the individual surgeons maintaining their legal right in the contracting and not getting yourself into problems. So right now I'm at Stedman Clinic. So contracting with industry, important considerations. This is just a not unusual image about a contract with here the contract sitting on the trigger for a mousetrap ready to ensnare the victim. So uh, just as you go through this process of contract, it can be with industry, with other entities. I just wanted to point out a few simple principles that I'd like to follow. And I'm not an attorney. If you come to AHF this year, as I'll mention, you will have a chance to talk to my attorney free of charge. Teresa Ford will be at the meeting. She's going to have her own desk that I'm going to sponsor just for your information to get you talk about these issues. So
That's for
some of the
talking with surgeons. She'll have the ability to talk with surgeons about contracting questions and things.
absolutely, yeah. And so you can already see that maybe I'm not good to talk about this because I can't even spell contract, but see at the top of the page. But uh, some of the things that you can get in a contract are a consulting agreement. This is a fee for service agreement, basically, where you do a task for an entity, you put in a certain amount of time, you get paid on an hourly basis. There can be product development agreements. These are can be based on time, but they can also be based on a royalty situation. One thing that comes up is just publications. So you're going to get, if you agree to do a book chapter for a publisher, or if you even publish a paper for an academic journal, you can get this contract to sign, and it can be important for you to look at it. Also, sometimes just educational events and educational events that you're going to go to, maybe as a participant, maybe you're going to be one of the faculty, and these can be from a cadaver lab to maybe a breakout session at a meeting where you may or may not get paid, but you may be asked to sign an agreement.
Hmm.
So before you sign, just consider this: when you get a contract or an agreement from an entity, this agreement is written by the entity's attorney, and you need to make an assumption that the agreement is one sided in its intent. So maybe there's some benevolent entities out there, but in general, the attorneys are hired to protect the rights of the entity you're contracting with. So this is right away, you need to be somewhat suspect of the content and take a look at it. So before you sign, rule number one, I'd say, is read the agreement. And I don't know how many surgeons I've talked to that, for instance, there's an agreement before an educational event, or we're both consultants for the same company. And I said, "Did you read it?" "No, I didn't read it. I just signed it as your standard agreement." Well, uh, there can be problems. Now, what, so number one rule, read the agreement. Secondly, with the agreements, do not accept liability, and especially when you see the word indemnity. So if you're asked to provide indemnity or says you indemnify an entity, this is something you shouldn't be signing. So uh, the basic principle is you're going to get paid a certain amount, maybe in this fee for service agreement, but consider also that the amount you're getting paid probably isn't bigger than if you just stayed home and did your normal job. So there may not even be a net benefit. So you shouldn't have a net liability or risk by signing the agreement.
Hmm.
Now,
Are there
one
different
thing,
ways that they use the term indemnity, Joel, or does it always indemnify the entity, or does it sometimes indemnify the surgeon?
yeah, it can indemnify the surgeon. Actually, I mean, uh, for instance, some product development agreements that I've been part of, the entity, like one of the big entities, like let's say, Stryker, Zimmer Biomet, or J&J MedTech, there should be clauses in the product development agreement that they're going to indemnify you or they're going to protect you from liability. So, for instance, we all know that J&J had to deal with quite a bit with the metal on metal bearing.
Hmm.
And this was, some of the designers were actually protected by the agreement. So they did indemnify them. But you'll also see the other way where you are asked to. I was recently got one uh, product development agreement that I'm working through with my attorney, but there was clauses that I was supposed to, in some circumstances, indemnify the company.
Hmm.
But you shouldn't be doing that. I mean, especially just picture this: you've got a company worth billions of dollars, and you're going to indemnify them. So you shouldn't be doing this.
Do you always recommend legal counsel review contracts, or is that the way you have it done?
I don't always do it. I mean, let's say, I'm going to show you a couple examples. Like
Mm.
you're asked to do a cadaver course. I'm going to show you an example of a company later on with that where I didn't call the attorney. Let me show you a couple examples. I didn't call the attorney. One was, just for this 1 day thing. You're going to teach people about cadavers, or there's going to be asked to give a lecture, and they're going to give you a temporary consulting agreement to give the lecture. It's not going to be worthwhile for me financially to, get my attorney involved and for me to spend a lot of time.
Yeah.
But still, you need to look at the agreement. And one option, too, that I've seen in situations like that is just as if you have onerous language, I just cross out the section and initial it and then sign the agreement, which they may or may not accept that. But
Yeah.
Uh, I'll talk a little more the next point. So I'm just kind of launching in here. I'm going to talk a little more about indemnity, these IP things as we go on. But one question you have to ask yourself: do you want to give away IP? It's not necessarily wrong to give away. This is your choice. You see, uh, maybe you're giving away some ideas that could produce future income. The main rule I'm saying is don't accept liability or indemnity. But many of the consulting agreements, particularly with the big implant companies I already made, they're going to have clauses that you working for them uh, means that they appropriate the IP that you disclose during the time of the consulting agreement.
And the
Now,
IP
another
is the intellectual property, correct? That's what IP stands for
correct,
there?
yeah, that's
Yeah.
what I'm talking about. We should
Yeah.
define that intellectual properties. So, one of the ways I look at, for instance, the intellectual property uh, and the fee for service or consulting agreement is that when they're paying me for an hour of my time, they got me for an hour of my time. They don't get my IP too, just because I worked for an hour. They already got the me hour of my time. I'd be giving my time. They don't get the IP for free.
Mm-hmm.
Now, maybe maybe they want you to work. Some company wants you to work on your some product, and they're going to pay you on a fee for service basis. Maybe the product isn't going to make much money. Maybe you're better off getting a fee for service agreement,
Mm.
getting paid for your hourly time than you are, let's say, getting a royalty of 1/2 of 1% of the sales. That's
Mm-hmm.
just a business decision you have to make.
Yeah.
But consider legal counsel. Read the agreement. Consider legal counsel. Now, a lot of times when you get the agreement, you'll get it in an email and it'll say the email would be introduced with something like this. This is our standard agreement. Call us if you have any questions. Okay, well, first of all, uh, I'm not going to call them if I don't understand the language. I'm going to call my attorney. Okay. So, and one thing to keep in mind is that the agreement, and this sounds stupid to say, but the agreement means what the agreement says. So, for instance, I've called a company, that sent me the agreement, and I've told them, talk to their, let's say, marketing who sent it out. And I said, I don't really like this language in this section, this paragraph. I don't like the language. And they say, why don't you like it? I tell them, they say, well, what this really means is blah, blah. And I said, okay, if you want to cross out what the agreement says and put in the agreement what you just told me over the phone, I'll sign it. Okay. But
Yeah.
what you just told me over the phone isn't what the agreement says. So if you come to some legal, the basic thing is, blah, blah, and the company, this individual told you, well, this really what it means. If you come to a legal dispute with them, what they told you over the phone 2 years previously isn't going to mean shit.
Yeah.
What means something is what the agreement says.
Yeah.
So you have to stick to that, what the agreement says, what the exact wording is. The other thing I've heard from companies too, call them if you have any questions. They say, well, we've never really enforced this clause. It's just in there just to emphasize to you how important it is to, let's say, not share IP or something. I said, well, if you don't plan to enforce it, just take it out and I'll sign it. Okay.
Right.
But you get all kinds if you follow the suggestion, call us if you have any questions. You're going to get all kinds of stuff, you see. But keep in mind, the key is what does the agreement say? And if you don't understand the language, talk to your attorney about it, you see.
Yeah. Yeah.
But you're not going to get the information from the company that's correct. Now, I want to just explain what indemnity means as we're going back to that. So, when you agree to indemnify an individual or indemnify a company or an entity, you are agreeing to act like an insurance company, and you're typically the way it's written, you're an insurance company that provides unlimited financial protection to the entity if such and such circumstances occur. And the circumstances that you'll see found, I'll show you a couple of contract examples later, but the circumstances may be very ill defined by the contract and they may be quite inclusive, you see. So, what do I do when I'm asked to provide indemnity when I get a contract? Well, one of the uh, initial responses I'll often make is say, if I sign the agreement with the indemnity clauses, I'm signing under false pretenses. Why is that? Because I'm pretending to be an insurance company with unlimited financial resources. Okay. Well, I'm not. Okay. So you're asking me to indemnify you. I c- Even if I want to indemnify you, I can't. So I can't sign the agreement because I'm
Right.
pretending to indemnify you and I have no financial capability to do it. Okay. Now, the other thing I'll tell the companies, I said, look, if you want to get an indemnity insurance policy to cover these occurrences, there's no insurance company in the world, including Lloyd's of London, which will provide an unlimited indemnity policy. Okay. You can't
Right.
get this anywhere. Okay.
Right.
You're asking me to give it to you, and you can't get it from the biggest insurance company in the world, you know?
Mm.
So the whole, it's actually kind of stupid, really. It's just, you're signing something under false pretenses, saying you can do something you can't. You're pretending to do something they can't get indemnity from anybody else. So even though you're an individual and you think, well, who am I? I'm nobody. And this is one clause that I've found you can probably in most cases get them to drop the indemnity clause just because of
Yeah.
these reasons, you see?
Is this I'm curious, Joel, is this an abundance of caution on your part, or have you seen situations where companies have enforced these indemnity clauses on surgeons that you're aware of?
I'm not aware of a specific case, but
Hmm.
it's things like this. This is the kind of thing that they'll say, we've never done this. We don't plan to do it. Well, then throw it out. It's a little more than caution. And I'll show you one agreement later on that's a little more than caution.
Okay.
I think that attorneys like clauses like this because it opens the door for more situations they can sue people in or more situations they can create a legal action, you see?
The attorney
Well,
representing the entity, you're saying, or
yeah, the
attorneys in
attorney
general?
representing the entity, yeah.
Yeah. Yeah.
And the final thing that I just say you should ask yourself, what you're basically is why should I risk my entire net worth? This is basically what you're doing. You're getting
Yeah.
paid $500 for an hour of your time, and you're risking your entire net worth.
A lot of, especially independent practitioners, will have created companies around their practice, and
Yeah.
while that company obviously can have significant assets and significant liabilities, to a certain extent, aren't some of those created to protect the individual's net worth? And does that help in these situations, or not so much?
Yeah, I don't know all the legal parts of that, but I think it is correct that if you have your company, your entity around that can, specifically one form of a company is called an LLC,
Hmm.
limited liability company. So part of those are established so you're not, the company is taking the risk, not the individual that owns the assets or manages the company, you see?
Yeah. Okay.
But, um, but this is, Uh, something that comes up. I see it again and again in agreements is the indemnity clause. Like, for instance, here in Vail, Colorado, we a lot of times hire people to plow driveways and during the wintertime, which most of us do in our neighborhood.
Hmm.
And I got the agreement from the guy, small businessman who plows the driveway. Well, basically, it had these indemnity clauses. And if you took the meaning of the contract he sent, is that if he was driving the couple miles on the road up the hill to my property and ran over somebody and killed him, I would be responsible because the he was on the way to do the job at my house. You see,
Uh,
and
uh,
so I'm just saying these clauses like this are not they're not just in the contract in here, but you can find it in a lot of little things like this
yeah.
that I don't want to. I'm going to pay you to plow the driveway. You got to be responsible for your any damage you create.
Yeah.
On the way here or during the driveway or something. But it's kind of, I think one thing going on in our society, and I can see it happening to physicians a lot. I call the game pass the liability, you see, where
Mm.
you're trying to pass the liability onto somebody else. The It was a while back, AAOS had an instructional course faculty lecture. I haven't been on it for a few years. I'm not sure what the current agreement says, but it had some language that those lecturing for at the in the instructional course lectures indemnify the AAOS against lawsuits should the AOS get sued because you did something like copyright infringement? Okay.
Oh, wow.
So I threw a bomb. What I did is I wrote a letter to everybody on the instructional course lecture and I said, don't sign it. So I figured if I just complain, nothing's going to happen. But if I throw a wrench in the works, they're going to fix this. Okay. I
Did they
threw a
fix
wrench.
it?
They did.
Oh, yeah.
But I was barred from the faculty that year, and, they were really the president was angry with me and everything, but they fixed it.
Yeah.
But it came out the reason they had that clause in there that the instructional course faculty for AOS, and we're all members of AOS, keep that in mind, we are AOS, the instructional course faculty, we had to indemnify our own entity because this was a demand put upon AAOS by the insurance company for AAOS.
Oh,
So
wow.
basically, the insurance company was requiring that the insured indemnify them. Part of the reason they did this is they had been sued over a copyright infringement thing. I think
Uh-huh.
somebody in their instructional course handout had made photocopies of some book chapters or something, you see?
I see.
And they gotten sued, so now their solution was to tell the faculty, the AOS members, to indemnify the AOS.
Yeah.
And that
Yeah.
was basically to indemnify the insurance company, you see, so some
Wow.
of these things you can imagine happening, like, maybe copyright infringement or the thing I'm talking about, the guy plowing the driveway or the small companies, and I'll show you one example, I think, later on too, that I was asked to sign indemnity and didn't do it.
Yeah.
Okay? We can so anyway, I don't think you should provide unlimited indemnity to any individual or entity you contact with. Of these indemnity clauses, I've gotten a couple of the big companies to take them out of their contract. Um, Consulting, fee for service agreements, I mentioned this a little bit, but you're paid for your time, so you wanna give up your IP for free. And this is kind of a choice. I mean, you're not incurring liability, but you just have to decide, is what they're paying you per hour, uh, worthwhile that you give them IP to help develop products, or
Mm.
is the IP a separate item? I like
Yeah.
to keep the IP a separate item from time. So, um, because a lot of the consulting agreements, they're built around I mean, the reason I have the consulting agreement with the company is more to participate in the educational venues, you see?
Yeah. Yeah.
So you can make a choice, try to tailor your agreement to be focused on the educational aspects you provide, not giving free IP to the company.
So if you're specifically working with a company on, for instance, a new prosthesis, and there's intellectual property involved, but there's also your time involved, right? Your ideas don't come without time. Do you generally try to structure those contracts that there is compensation for both of those aspects, or if you're dealing with intellectual property, do you ignore the time component of it?
Yeah, if I'm dealing with IP, and it's something to do with the tax laws too. You can contact, ask your attorney, ask your accountant even, that if they, let's say you're developing a new hip prosthesis and they're paying you hourly to develop the hip prosthesis, well, then you've already been paid for your IP, and then the
Hmm.
royalty you receive will probably be taxable as regular income. Whereas if you just all your time is for free and the whole transaction is a transaction of intellectual property, then you can claim it as a capital gains
I
because
see.
you traded something you already owned for something else. So it's actually a capital gains, and the taxation of capital gains income is of course lower than taxation of regular income.
So this might be a case by case basis depending on what you're developing, huh?
Yeah, and some of the companies, you can kind of have it both ways in a way that if you spend you know days and many hours over the course of a couple of years developing a product, and the company uh, never markets a product, it can be in your contract that you are paid for your time, as
Hmm.
if it's a fee for service agreement. You see, but if the product actually goes to market and you're going to get a royalty on it, you may be better off. You're probably going to be better off tax wise if you're never paid uh, for the time you spent developing the product.
Okay. Interesting. So there's ways to be flexible with those contracts.
Yeah, yeah, there is, and some of these things are maybe cost neutral to the company. One thing I was going to bring up too about the fee for service agreements, a lot of them have when you give an educational presentation, and you should read this part of it, that some of them say that the uh, entity that you gave it for now owns all of the material in it. It may even have some clauses about IP connected, the imperial material presented. It says that it may say it owns all the copyrights, potential copyright to the material presented. You see,
Hmm. Hmm.
so you probably are going to want to reword something like that because this is something you created. Yeah, I mean, you owned most of it. You spent some time. They paid for you for the time, but probably as most of us do, you're going to resort a lot of slides. You're going to maybe tweak it a little bit for this particular occasion, but
Yeah.
most of it is stuff that's come from the knowledge that you've built up over years in orthopedics, and you want to be able to use it.
Mm.
So, anyway, if you sign a standard agreement, you may not only give up, your time, but you might give up your IP. You might give up ownership of presentation materials, and worse, you might even indemnify them for use of the materials. Like, so my suggestion is don't give up IP for free. And then also, you can allow a non-exclusive license for the entity to use your presentation.
Mm.
So, yes, after you talked at such and such meeting, they can use your presentation, but it's a non-exclusive license they have to do it.
Mm.
Now, there was one some years back, and I got the company to change it. I won't say the company's name, but um, they had clauses as far as your fee for service agreement. First, any IP or ideas you disclose, they automatically own. And then it goes on further to say if they, let's say, take your idea for a new product and they make the product and they get sued by some entity for, copying something or patent infringement, you indemnify the company for loss. So, first, they stole your IP. Secondly, if they used your IP and got sued for it, you have to pay all their legal costs.
Oh my goodness. Oh my
Yes.
goodness.
So there was the one company involved. Uh, it was some years back. It was and maybe 15 years back. And I called the other consultants. I said, "Did you read the agreement? Do you know what it means?" They said, "No, I didn't read the agreement. I just signed it." And so I ended up meeting with the president of the company about this, and finally it got changed. Their initial offer was, well, your indemnity is limited to $1 million. And I said, well, this just shows how stupid your agreement is. You pay me 500 and I risk a million, I mean,
Yeah.
why would I sign this? So,
Yeah.
um, yeah. Anyway, read the
Huh.
agreement. Okay. Then, I was going to just bring up, maybe to close here, examples of a couple recent documents I was asked to sign. Okay.
Yeah. Let's look at it.
Yeah. Here was I was going to teach. So I'm a consultant for the company. I'm going to teach at a cadaver lab. And then I get a document that I signed before the cadaver lab, and it's reasonable waiver of liability and hold harmless agreement, which means, if I get stabbed by a knife or, somebody runs a drill bit through my hand, I'm accepting the risk. Okay.
Mm.
But what actually happens is this agreement goes beyond waiver of liability and hold harmless. It says, I agree to indemnify, defend, hold harmless. I've crossed out the company name from
Mm.
any claims that may arise from my participation in this course or another course. Well, this is potentially a risk. I mean, you are in a cadaver lab, okay, and we got sharp stuff, we got knives, we got power equipment. Is it possible for me to hurt somebody, or for them to contract a disease because they run a knife or drill bit through their hand? Demonstrate, of course. You can't sign this. Finally, after getting the other faculty involved, the company deleted this clause. But they were
Wow.
actually also asking the participants were all being told to sign this agreement, you see? And the participants weren't even getting any financial compensation. They're there to learn, and I can see how they can release liability, but they shouldn't indemnify the company. And
Wow.
then, and I'm putting the name of the company here because you can find this on their website. It's public information, and it says Viticus Labs agreement to teach or go work at their lab. So again, it's called a waiver and release of liability agreement. Now it says in the agreement, I agree to defend, indemnify, hold Viticus Group harmless, free and clear against any and all demands, claims, it goes on and on. And that's what I mean. These things go on and on. So this is a company that's not that big, Viticus Labs.
Yeah.
And you do something in their lab and hurt somebody and they sue Viticus Labs. You think Viticus Labs not going to come after you?
Interesting. So, what do you think they mean by defend here? I'm kind of curious about that.
Well, that means interpret it as a legal defense, you see.
Yeah. Yeah.
You're going to have to do a legal defense, you see. And so the thing that comes up is, let's say, but the essence of this is too, let's say somebody at your table said, you know, you, let's say it's a spurious, stupid lawsuit, like
Mm.
they said, the individual claims, well, you, uh, you know, stressed me out. You've applied great stress that has caused me anxiety for weeks afterwards by belittling me during the lab or something. Okay. So
Sure.
it's a stupid suit. It isn't going to go anywhere. When you indemnify, so you're indemnifying him against all claims, demands. So even if it's something stupid, indemnify means you're going to pay the legal costs.
Right.
They had to get
Mm.
their attorney involved to defend it or something. So there are probably some of the big companies probably not gonna go after you. I think something like size of Viticus Labs, potentially they could, you see?
Yeah.
Um, the, stuff like that going on.
Hmm.
Okay, now, I'll just get I've got one more just example. So I was asked before one of the big meetings to come early. We were gonna have like a several-hour session teaching anterior approach, lectures on anterior approach. This was initiated by a company that wants to sell drapes for anterior approach. So
Hmm.
my job, show up, give a lecture. They're going to give me a fee for giving the lecture. I'm not going to endorse the drape. I'm just going to talk about how I do anterior approach.
Hmm.
But in order to give the lecture, I'm given a consulting agreement with indemnity provisions, also that IP provisions that
Wow.
could extend. I'm involved in anti approach, so I mean, if I want to develop some drape with somebody else, could this could be sticky. And then also that the presentation materials they own, uh, they claim ownership, and I indemnify them for use of my presentation materials. So this is
Wow.
just to give a lecture, but I don't know. I crossed out the company name. I won't go into it, but just kind of how some of the stuff reads: consultants indemnity. Consultants shall indemnify, defend, hold harmless company and its shareholders, directors, affiliates, officers, employees, representatives, collects against all losses, liabilities, damages, demands, claims, suits, actions, cause of action, costs and expenses of any kind of a third party claim, so this tip pretty typical language. And then the IP section, intellectual property, all ideas, inventions, discoveries, designs, prints, plans, data, improvement, derivative. So if you want to improve on their thing or they claimed you derived, uh, this is all owned by uh, the entity. Plus, you indemnify them for using your stuff. So
It's easy to see just reading this language why so many people would want to skip this over, right? I mean, it's so obtusely written and can be difficult to parse through for somebody who's not as used to it as you are.
right, yeah, and consultants shall, without further consideration, disclose all inventions promptly to assign inventions to cooperate and do all things necessary to assist them. It's like you. I'm just going to show up and give a talk. I'm talking about angel approach. I don't know. I don't even know what your product is. I'm not going to sell it.
Right.
You know. It's just it. It goes on and on. But anyway, so, just to kind of sum up, read the agreement. I say don't accept liability, especially don't agree to indemnify entities. Consider IP, is fee for service enough for you, or do you want to protect your IP? And of course, consider legal counsel.
Hmm.
And uh, at our AHF 2025 meeting, Appetite for Disruption, which I have, of course, June 6 to 7, 2025. I'd say attend AHF. We want you to. And there you can meet and ask questions with Teresa Ford. She's my attorney for a number of years uh, with the contracting, look at the elements of contracting. And she's going to be in the AHF exhibit area. She's going to have a desk. She's going to answer questions, give information free of charge. Another thing I didn't mention in the
Wow.
presentation is the issue of compliance, whereas this Department of Justice regulations that govern or contracting with companies. Usually, the big companies are pretty up on this. You don't get into trouble, but you can end up contracting with a little company that maybe isn't up on compliance and potentially get into. You don't want to get in trouble with the DOJ. But
Yeah.
that's what a client's about, and a good attorney will help you make sure your agreements are compliant with, uh, Department of Justice guidelines also.
And Teresa, who's going to be at the AHF, where does she practice out of?
She practices, and she's now in the state of Washington,
Okay.
outside Seattle. She started in Texas, down in Houston, but she has, a number of clients all over the country and communicates by, uh, like you often do, the attorneys email and phone. And if somebody specializes in physician contracting, I'm sure there's
Wow.
other attorneys out there too, but I mean, she's known in the industry. So if she uh, is in discussion with somebody at the big implant companies, they know who she is and that she's knowledgeable in this area.
We have such an intersection of innovation, technology, industry, and surgeons at the AHF meeting. In general, it's
Yeah.
going to be fantastic to have her there as a resource.
Yeah, I think so. Yeah, everybody should stop by, say hi, and if you have any questions.
So, Joel, it sounds like, if I'm hearing you correctly, like in a lot of areas in contracting, you are your biggest advocate. Is that right? And then, secondarily, have somebody who can advise you if you don't know what the language means.
Yes, that's correct. Yeah, I mean, you have to be an advocate. Sometimes talking to Teresa, she gets a little frustrated with some of her clients because she thinks they give in too easily.
Yeah.
Like they say, "Well, they're not going to enforce that," or "Yeah, I'll sign it, no problem." And the it's surprising sometimes. I mean, I'm uh, better known, obviously, than a lot of the young surgeons who are going to be involved in contracting. But still, you have to don't be afraid to speak up and question things in a contract or just say you can't do this. Like
Yeah.
I would personally. I guess I'm on a little uh, mission that I'd like to see these indemnity clauses just disappear because uh, they're basically nonsense. Individuals can't indemnify these big companies, and it's not good for you to risk your entire net worth over something like going to a cadaver lab to teach or learn.
Yeah. Which is can be a tremendous career builder for a young surgeon. I do think it's got to be difficult for some young surgeons in practice who aren't, don't have the reputation of a Joel Matta, like you said, are going to feel some pressure to accept some of these clauses that, you know, uh, in theory won't put them at risk. But like you said, what's written in the contract is what's written in the contract.
Yeah, I think you're absolutely correct, Joe. And that's when I'm talking about this game I call Pass the Liability. I think we're targets. We're targets because acting as an individual, sometimes it's difficult to say, do we really have power against some big company,
Yeah.
and they can just say, well, screw that guy, we'll get somebody else. So it
Right.
is a little difficulty, but I think maybe just bringing up some of these questions and, companies that, in the contracting process, be it a publisher, be it an implant company, be it, you know, some commercial entity, if they keep hearing this again and again,
Yeah.
I think it's can potentially disappear or change.
So, is there any room for just saying, as surgeons, maybe we just don't work with companies anymore? Or is that something that, doesn't do us good in the long run?
I'd like to think that I've made an important contribution to human health and well-being by working with companies
Yeah.
that getting you know beneficial products available for use in medicine, I think, is one way to make a contribution to medicine.
Yeah.
So you know I I'm not in favor of stopping to work with companies or commercial entities. It's been, and I think it's a little bit sad in the way that sometimes it's almost talked about like it's shameful. You're making money from products or something, or it's shameful you're working with there's kind of this little undercurrent I sense sometimes,
Hmm.
but I think it's actually an important function, and I believe in capitalism and medicine. I think capitalism advances medicine. I think the for-profit aspects of it are very important in advancing innovation and products.
Well, Joel, I couldn't agree with you more. And I can't thank you enough for the time that you've shared with us and for being the pioneer, first of all, in the anterior approach, but now being the pioneer in the AHF podcast series on Cut for Time. I couldn't think of anyone better than to give us our first talk in this series.
Well, I'm still a little miffed because I got cut, Joe. I mean,
That's fair. That's fair. I can't do anything about that. Well, I suppose I could do something about that.
no, but no, I'm happy we're doing this, and I think what you've been involved in, we want to do is make the uh, AHF website educational source also,
Yeah.
and whether or not you call this talk education, I think it certainly should get people's mind working.
Yeah. Well, thank you so much, Joel. I really appreciate having you on this episode of the AHF podcast. And for our listeners out there, please take a moment to like and subscribe. You'll be helping us find more people just like you to share our content. And as a subscriber, you can always drop an idea for a topic or any feedback you'd like in the comments below. You can find the AHF podcast on Apple Podcasts, Spotify, or in any of your favorite podcast apps, as well as in video form on YouTube /at Anterior Hip Foundation, all one word. New podcast episodes come out on Fridays. I'm your host, Joe Schwab, asking you to keep your hips and contracts happy and healthy.